Hello, members. Welcome back to Agora Legis, the platform of legal minds. Here we discuss legal principles and make them easy to understand. And in today's session, we are going to dive into Land Law 1 and we shall discuss the principles on fixtures and chattels. So, without further indulgence, I'm Counsel Ben and let's jump right in. So, defining fixtures. First of all, according to section 18, subsection 4 of the Landlords and Tenants Act, fixtures refers to personal properties of tenants that are attached to premises as so as to be regarded as immovable. Furthermore, in the case of Billing versus Peel, reported in 1954, Lord Goddard stated that fixtures are things attached to the land so as to be integral part of the land. They cannot be removed. Continuing, we shall see also in the Black's Law Dictionary, ninth edition, on page 713, that fixtures are defined as things that are attached to land, permanently attached to land, and are forming integral part of it. They cannot be removed without causing substantial damage to the land. After defining fixtures, we are going also to explore the famous rule about fixtures, that is the Latin maxim of quick quid plantatur, solo solo sed it. That means whatever is attached to the land is forming part of the land. Literally translating it from Latin, it means that whatever is planted is given. So whatever is in the land or is attached to the land is automatically part of that land. So automatically property of the owner of the land. And that is the general rule about fixtures. And uh, there is this authority that really shows very well how these rules applies, because in Megary's manual on law of real property, she says that even if a building was constructed using stolen materials, they all in law become gifts to the ultimate and absolute owner of the land. So there is no other way you can say uh, this building was constructed, I don't know, with stolen materials, so they should be given back. No, since it's already fixed in his land, it automatically becomes his own property because he's the ultimate owner of the land. It was shown in the case of Francis Valles Ibitoye, where uh, two parties intended to enter into a sale agreement of land. However, before before closing the sale agreement or before finishing the sale agreement, he had already started constructing buildings on the land, and later on the sale agreement failed. So he wanted compensation for the houses he had built on the land, and the court held that there is no compensation needed or there is no compensation owed because it's it's a fixture and it's already given to the ultimate owner of the land. So we shall go now into chattels, and chattels are defined according to Merriam-Webster Dictionary, 8th edition, published in 2002. Uh, chattels include uh, chattels include properties that are that are attached to the land, but temporarily attached to the land. So, according to Merriam-Webster Dictionary, 8th edition, published in 2002, chattels are properties temporarily attached to the land that might be removed without causing substantial loss or substantial damage to the land. And Uh, Here now we shall go into seeing how do we determine whether a property is a fixture or it's a chattel. There is a Ugandan scholar who is John T. Mugambwa in his book Principles of the Land Law in Uganda. On page 52, published by Fountain Publisher in 2002, uh, who establishes those two major tests in determining whether a property is a fixture or it's a chattel. And the first test is that we have to look at the degree of annexation, and that's being the first text, the degree of annexation. To what extent is the property attached to the land? And here we shall see that properties that are attached to the land and forming part of it, attached to the land by some other means other than their own weight, are considered to be fixtures. And whereas for chattels, they are attached to the land by their own weight and they can be removed without causing substantial damage. Uh, we shall go to the purpose of annexation. That is the second test in determining whether a property is a fixture or a chattel. So, purpose of annexation refers to the objective of attaching or of affixing that property to the land. And here we shall see, by the way, in the famous case of ATC versus Uganda, ATC Uganda versus KCCA, Kampala Capital City Authority, reported in 2019, where the main issue was whether this mast network, I hope you know the network masts, they were fixtures or chattels. So here, the general rule in the second test is that uh, a property that is attached to land so as to enhance the utility and the value of the land is considered to be a fixture, whereas a property attached to land, but for the purpose of enhancing its own utility, its own value, or its own the enjoyment of the very property is considered to be a chattel. And that is the general rule. And it was seen in this case of HCC Uganda versus KCCA in 2019 that uh, these masts, network masts, were chattels since even though they were attached to land, their use or the purpose of annexing them to the land was not to enhance the value or the utility of the land, but rather to just enhance the enjoyment of the chattel, enjoyment of the property, their own utility and their own value. And that said, we shall go to uh, types of fixtures, where we shall see landlord fixtures and tenant fixtures. And after that, one point remaining will be the exceptions when it comes to fixture, where the right of removing fixtures. So, types of fixtures include landlord fixtures. These are permanent fixtures that cannot be removed at all because the tenant found them in the land and he cannot take them away. However, the tenant fixtures, these are part of those exceptions. They include fixtures that can be removed from the land after ending the tenancy. And here we see there are a number of tenant fixtures like trade fixtures, ornamental fixtures like curtains. You have some flowers you attached, let's say, to a wall. You have something you attached that is ornamental in the house. It can be removed after the tenancy. The agricultural fixtures, other than trees, can be also removed It was seen in the case of Bain versus Brand. The court, uh, the court held that fixtures could be removed. Fixtures, okay, those agricultural fixtures could be only removed when it's not a tree. So uh, we shall go further and see now those exceptions. When can a fixture be removed? We shall start by section 3, subsection 4b, where of the Land Act Cap 236 of Uganda, where it said that in the Milo tenure system, they they separated the ownership of the land from the ownership of development made on the land. So here, it means that whatever development you put on the land, when you own land under Milo tenuureship, tenure system, uh, you can remove it because uh, the ownership of the land or of the soil is separated from the ownership of development on the land. Actually, the second exception is stated in the rule of uh, acquiescence estoppel. That refers to, okay, that can be proven when it's shown that a landlord convinced a tenant that he had interest in the land, that he had ownership on the land, and that he could also have he could also have that title on the land. So when the landlord convinced the tenant and the tenant made some improvement on the land, or he developed the land, or he built on the land, such landlord is stopped from evicting them afterward without any compensation for the development on the land. It was seen in the case of in the case of Ramsden versus Dyson, where the respondents built houses on the applicants on the appellant's uh, land, their father, and their father knew that he was aware of these developments made on the land, and he acquiesced. To acquiesce means to accept without any protest. And afterward, he wanted to evict them. And when they refused, he sued them. And the court held that since he had already convinced them that they would succeed to him, to this land, and he had already convinced them that they had an interest on this land, he could not evict them without compensation for those fixtures they had planted in the land. So, members, we have appreciated the laws on, or the principles on fixtures and chattels. And for more information on this topic, I urge you to go to the other channel that we are developing with our friend Council Hamza, a very good scholar who also provides good advice when it comes to legal principles on the um legal mindset at the bar. He will also help you. I urge you to like, to share, to subscribe if it was helpful for you, and see you next time. Thank you for watching.